Ladies and gentlemen, today we are going to see Tamil Nadu Regulation of Rights and Responsibilities of Landlords and Tenants Act 2017, simply called as New Rent Act to Tamil Nadu. Tamil Nadu's new Rent Act, we are going to see its advantages, how this act is advantageous to landlords, how to get benefits under the new act, what are the advantages to the landlords, and what are the latest judgments on the new act, who can apply under the new rent act, and how to apply how to deal your tenant under the new Tenants Act, Landlords Act. There is a Rent Act are all discussed in this video. Okay, let us go to the video. See, previously there was an act called Tamil Nadu Buildings and Lease and Rent Control Act. The act, it was passed in the year 1963 or 67, it seems. The old act gave several benefits, protections to the tenants. So under the old act, it is very difficult to vacate a tenant because it gives various protections, various benefits to the tenants. So when you apply under the old act, the judge not only will see whether the petitioner landlord is entitled to such a petition, he will also look into the bona fide of the claim. So even for our default, the judge has to see whether the default in paying the rent is whether willful or not. He will give eviction only if the default in paying the rent is willful. Similarly, when a petition is filed for owner's occupations or for additional accommodation or for any other ground, the judge will weigh whether the benefits and advantages and disadvantages to the landlord as well as to the tenant. See, if the eviction is passed, what will be the advantages to the landlord? What will be the disadvantages to the landlord? If the order is passed against tenant, what will be the disadvantages and what will be the advantages? Then the judge will weigh who will suffer a loss in the event of a judgment passed as against them. So in that case, after weighing seeing the consequences, then only the judge will apply his mind and pass some orders. Further thing, the judge has to go through has to look into various aspects, various documents, and you have to analyze all the backgrounds, details, documents, etc. of the landlords and tenant. Then they have to apply his mind and they have to come to the conclusion. So for those things, it took a long time for the disposal of the case. So the rent control eviction is something like an impossible. It's more or less like an impossible thing to the landlord under the old act. So for under the old act, when you file a case for eviction, he has to face it. The trial court itself took time about 5 years. Then appeal court take another 5 years. Then High Court in CRP took another 5 years. Then Supreme Court takes another 5 years. Altogether, more than 10-20 years. The landlord and the petitioner has to rush to the court, and they have to take several steps, and they have to incur unnecessary and abnormal expenses towards court and for the other litigation, and so it was something like more or less impossible to the landlords to get an eviction case, to evict a person from the premises. So for that is under that circumstances, most of the landlords lost their faith on the court and law, and so they went to the police station and they went to the gundas, rowdies, politicians for evicting the tenant. So the law and order problem, it automatically created a law and order problem, and so it indirectly developed or indirectly created the bad faith on the court and law, and they were and indirectly each and every landlord was constrained to approach politicians and other rowdy elements for evicting their tenants. So under these circumstances, to give reasonable protections and to give proper relief in a timely manner, this new act has come into force. So under the new act, the procedure is very simple. When the landlord applies the court and proves only two conditions, that he is the owner of the property and he wants this property, only if these two conditions are complied, automatically the judge they'll pass an order for eviction and give the relief as prayed for at the petition. So under the new act, it is like something like more or less going to the shop and purchasing goods. So landlord, just like shopping, he can just approach the court. He just simply asks the court, give an eviction order. Then the court will pass an order, and that also pass in within a short period of 3 months, as fixed by the law. So it is a quick relief, and it is not there is no hard and fast rule. They can simply file a petition and just establishing two things. One is he is a landlord, and the second is he wants the property. He did not say any reasons, or he did not disclose any, establish or prove any requirements or bona fide to the court to get his relief. So it is more or less a gift, or a very gift thing, a very wonderful thing to the landlords to get an eviction order as against the tenant and to get the relief within a short period of time. Now the Act gives various grounds. One of the ground is that if there is no rental agreement, return rental agreement, then on that ground itself the landlord can file a suit and file a petition and get an eviction. Then if the person refused, if he did not pay the rent for more than 2 months, and if there is a misuse of property, or if the property is required for owner's occupation, or for owner's usage, or for any nuisance is committed by the tenant, he can simply file a petition, and once the petition is filed in, the judge will the acts replace that this case is to be disposed within a period of 3 months, and the landlord also can get the relief under this new act. So what is the difference? If you look into the difference between the old act and the new act, as far as the old act is concerned, the procedure contemplated therein took an abnormal time for considering various facts and materials and for arriving a conclusion. The long inquiry proceedings, examination, chief examination, cross-examination, marking of documents, and that procedure automatically prolonged the proceeding times, and ultimately the case time went for years and years, and ultimately it became an impossible thing to the landlord to get an eviction of the tenants. So now under the new act, once the petition is filed, automatically the judge, the person, as per the present act, the petition and copies of the documents are already served even before the first hearing to the tenant, and the tenant is expected to file the counter on the first hearing itself. So he can for the first hearing he can file a wakalat, or at least for second or third hearing he must file his counter. Otherwise, the court will not give any time. Under the present act, if the person seeks adjournment, then the court may also insist to pay the cost, say 1,000 rupees or 2,000 rupees to the other side for granting this adjournment, and towards the expenses or loss to the other side. So this provision automatically puts pressure on the parties to conduct the proceedings in a speedy manner, and they cannot simply get an adjournment. And if they seek an adjournment, they have to pay 1,000 rupees or 2,000 rupees towards cost to the other side. So it automatically prevents such a delay in the proceedings. Then again, when under the old procedure, all various facts were considered and various duties were cast on the judge to consider whether whether the claim is bona fide or not, or whether it will cost how much loss is cost to tenant or to the landlord in the event of a particular order is to be passed. Here it is not so. Here the judge has to look into only two things. Number one, whether the petition is filed by landlord or not, whether the other person is a tenancy or not, with tenant or not. Then whether here the rental agreement is there or not. So for this thing, he did not examine any party. There is no CG economic is necessary, no cross examination is necessary. And the first, once the counter is filed, on the next hearing itself, the case will be taken up, and the judge can pass orders or immediately after hearing the argument. So first hearing is they have to file a counter. The second hearing, the judge can hear the arguments, and third hearing, he can pass the judgment. And with these three hearings, the judge can close the case within the period of 3 months as expected in this act, because the judge need not go into the long did not apply his mind. He did not verify various facts, bona fide or advantages, disadvantages, alternative inconveniences are all. It's not at all necessary for the judge to consider all those elements. So judge has to simply see if the case is filed on the ground that there is no rental agreement. The judge can simply ask the other side, do you have any agreement? No, then you go, get out. Like that, he can pass an order, eviction order. Similarly, if there is on any other ground also, the judge need not go into in deep to see whether the claim is bona fide or not. The bona fide element is not one of the elements to pass an eviction order under the new act. So this is shortened procedure, shortened expectation of this act, automatically shortened the proceeding time, length, procedure, and so the judge can easily dispose the case within the period of 3 months and give the relief to the appropriate parties. For this, so in order to approach, and again, once the eviction order is passed, the other side can go for an appeal to the rent control tribunal. Even that appeal is to be disposed within a period of 3 months, 30 days. 30 days. So initially 3 months for the main case, original case, and appeal time is 30 days. So 90 days, the judge, the case will, the issue will come to an end, and the eviction can be done within a period of 90 days. So there is no appeal as against the rent control tribunal. So rent court will pass an order, has to pass an order within 90 days, as against which a person can make an appeal. That appeal has to be disposed within a period of 30 days. As against that, there is no such appeal. So eviction can be done within a period of 90 days. So in order to avail this new act and the benefits under the new act, there are two elements is required. One is registration, written agreement. Written rental agreement is necessary, and registration of that agreement is also necessary. So only if there is an agreement, rental agreement, and a registration of the document with the rental authority, then only that parties alone can approach the rent court, and now other parties has to go to this regular civil court, which will take a long time. So there was a confusion. So supposing a person became a tenant in the year 2000 or 2010 or 2011 or 15, then they may not be having any rental agreement, or even if they have a rental agreement, it might have expired. So there was a confusion. So the Act stipulates that the rental agreement is necessary, without which they cannot approach the court and one place. But there in the Act itself, it gives one ground which says that if there is no rental agreement, that can be a ground for eviction. So when there is a confusion is there, it was referred to our High Court, and our Suresh G. Honorable Justice Suresh G. It seems J. Has clarified that any agreement for those persons who has no rental agreement, they can file a case and it is to be registered, and on that ground alone a tenant can be evicted. So that for filing on a new eviction petition under the first ground, so 22 2A, which says that when there is a no rental agreement on that ground itself, a landlord can file a petition for eviction. For that such petition is permissible under the new act. So when there is a no rental agreement, a person can file a petition under the new act and get a new relief. So this subsequently on a latest judgment which is now passed by our Honorable Justice Subramaniam J. This is passed on 4/2/2022. This judgment Subramaniam J. Of Madras High Court has clarified what are the petition can be filed under the new act and what are the petition is not made under the new act. So in his judgment it is clearly specified that if the rent is commenced before the act came into force. So this act was passed in the year 2017 and this act came into force in February 2019. So this act is in force from 2019 February. So if a tenancy commenced before 2019 February, so a person can file an eviction petition under this act on the one and only ground saying that there is no written agreement, and on that ground he can file a eviction petition and get an eviction order from the court, and that can be disposed within a period of 3 months. So this quick relief can be obtained for all the tenants, all the landlords whose tenancy has commenced before February 2019. So as far as the tenancy commenced after 2017 is concerned, registered rental agreement is a must. You must have a registered return agreement that must be registered with the rental authority. So now you may be having a confusion. So registration, you may think that the registration is to be done with the concerned sub-registrar office. The registration with sub-registrar is totally different from that of the registration which is to be done with the rental authority. As far as the Registration Act is concerned, if the lease is for more than 11 months, say 12 months or more than 12 months, then in that case registration is compulsory. That registration is to be done with the sub-registrar office of the concerned area where the property is located. The registration is separate. In addition to that registration, additional registration, what is the registration with the rental authority is also required to file any petition before the Rent Control Board or rental authority and to get any relief under the new Rent Act. So further thing, we can apply online registration. It is a very simple procedure. You can get the online website address. There you can upload your details. You can upload the rental agreement, copies of the rental agreement, and also you can upload the ID proof of agreement, and you will have to pay a nominal fees of ₹100 rupees only. So on that ground, it can be registered in a simple method. The deputy collector of the concerned district is nominated as a rental authority. So you will have to register this rental agreement through the online procedure with this deputy commissioner, the deputy collector of the concerned district. So the procedure will help you to avail this benefits under the new act. Supposing you do not have registered, you do not have any rental agreement, or you did not register any such rental agreement, you can simply request your tenant to come forward and to make any fresh lease agreement. So that agreement can be done even today or even next month or next week. Then you can take this agreement, the newly made rental agreement with the concerned. We can make a new rental agreement and register it we can make an online registration with the deputy collector. Then thereafter you can file any petition for eviction under the new act, and you can get benefits out of the new act. So even if you do not have any rental agreement, don't worry about that. You ask your tenant and ask him to make a new rental agreement. On that basis, you can make a rental agreement and get it registered with the concerned deputy collector through online registration. Then you can invoke the new act. So this is the procedure. So the new rental act is gives a lot of benefits, advantages to the landlords, with which you can simply file a petition and get a eviction order within a period of 3 months. Even against which, if the other side prefer an appeal, that appeal has to be disposed within a period of 30 days. Then there is, as against that, there is no appeal. You can simply file a petition before a execution court and get an order of eviction within a period of, and you can evict the tenant within a period of 90 days. This is the advantages and most beneficial legislation to the landlord, and it will be beneficial to all. So I hope this video will be useful to all the landlords and owners of the property. So I hope you will get and you may share this video to your friends and relatives who regularly require any doubts or clarification on this new Rent Act. So please, you may watch my video and gain your knowledge. Legal knowledge will not only give you power, it will also give you enough courage, and you can have a comfortable life in your day-to-day events. So with this, I will come again with another topic. If you have want any doubt, you can watch my video. You can open my channel Raziaq Latube, which is in English. If you want in Tamil, you can open Raziaq Sattam Arivom. There are a lot of videos and there are a lot of playlists, and you can, from that you can select the topic and get you watch the video and get your clarify your doubts, and you can acquire necessary legal knowledge. In addition to that, if you want to have any other doubts, you may also contact us, and we are ready to give you clarify your doubts, and also you are also ready to give you the necessary legal opinion as may be required to you to sort out your problem and to solve your legal issues. I will come again with another topic. Until then, goodbye. Raziaq Ali.